You are a law-abiding gun owner, valid permit, clean record, certified training. You have done everything right, everything the law requires, and the moment you cross into California, you are a felon, not a suspect, not under investigation, a felon. For exercising a constitutional right that 35 other states respect without question. No warning, no grace period, no exceptions. Just a felony charge for carrying a firearm. You are completely legally authorized to carry everywhere else in America. That system just got permanently destroyed in federal court, and what replaced it is going to change the legal landscape for gun owners in every single restrictive state in this country. I'm Michael, 5 years in the firearms industry, and this is Gun Guide Pro. Let's get into it. Before we go any further, if you are serious about protecting your Second Amendment rights, subscribe to Gun Guide Pro right now and turn on every notification. We are a new channel, and we are building something real here. Every single subscriber tells us that this content matters, that you want honest, accurate, plain language coverage of the legal battles that actually affect your rights. Hit that subscribe button, hit that bell. Your support is what keeps this channel alive and growing. And trust me, the cases we are about to cover over the next several months are going to matter enormously to every gun owner in America. For over 20 years, California operated under one simple policy when it came to out-of-state gun owners. Your permit means nothing here. Did not matter if you were from Texas, did not matter if you were from Florida, Arizona, Georgia, or Tennessee, did not matter if you passed the exact same FBI background check that California requires, did not matter if you completed certified firearms training that exceeded California's own standards. The moment you crossed into California while legally carrying, you were committing a felony. No gray area, no reciprocity, straight felony exposure. Now I want you to sit with that logic for a moment because it is worth examining. Your home state ran your criminal history, verified your identity, confirmed your training, checked every box. California looked at all of that, verified, documented official information, and said, we do not trust any of it. Your state's judgment means nothing. Our bureaucracy knows better. That is not a public safety argument. There is no data supporting the idea that out-of-state permit holders are dangerous. In fact, FBI data consistently shows that out-of-state permit holders commit violent crimes at rates lower than off-duty law enforcement, lower than off-duty cops. California was not protecting anyone. California was targeting law-abiding gun owners with deliberate, documented discrimination. Drop your answer in the comments right now. Have you ever been stopped from carrying in another state because your permit was not recognized? Which state did that to you? I read every single comment, and I want to build a real picture of how widespread this problem actually is. The case that just ended this 20-year discrimination is called MillerVCalifornia. Earlier in 2026, federal Judge Patricia Ramos issued a preliminary ruling declaring California's non-reciprocity law unconstitutional. That was already a significant win, but California being California, they did not accept it. They came back to court with what they called a compliance solution, a new system for out-of-state permit holders to apply for carry recognition in California. And what did that system look like? 6 pages of requirements, county-specific applications, meaning you had to apply in specific approved counties, not just anywhere in the state. Multiple sworn affidavits, additional conditions and qualifications that California's own residents never face when getting the exact same permit. California's strategy was transparent. They could not openly defend the discrimination, so they tried to replace it with a different kind of discrimination. Same result, different paperwork, same intentional barrier between law-abiding gun owners and their constitutional rights. The plaintiff's legal team brought this back to Judge Ramos with one argument that cuts through all of the bureaucratic noise. Constitutional rights should not require navigating an administrative maze designed to exhaust and discourage people from exercising. Judge Ramos agreed completely. On August 19th, 2026, she issued a permanent injunction. No complicated applications, no county-specific restrictions, no sworn affidavits, no 6 pages of conditions. The law is unconstitutional. It cannot be enforced, period, full stop. Now, here is what makes this ruling genuinely different from most Second Amendment victories, and why it is so much harder for anti-gun states to dismiss or work around. Judge Ramos did not rule exclusively on Second Amendment grounds. She applied the Equal Protection Clause of the 14th Amendment, and she applied it under strict scrutiny, the highest legal standard available in American constitutional law. Let me explain what strict scrutiny actually means in plain language, because it is important. Under strict scrutiny, the government must prove 2 things to justify treating people differently. First, a compelling government interest, an actual, documented, evidence-based reason for the discrimination. Second, that the discriminatory policy is the least restrictive means possible of achieving that interest, not just a reasonable reasonable approach, the least restrictive approach available. California failed both tests and failed them convincing. On compelling interest, FBI data shows out-of-state permit holders commit violent crimes at lower rates than off-duty law enforcement. There is no public safety justification for treating them as presumptive criminals. The data does not support it. The argument does not hold up. On least restrictive means, that 6-page county-specific sworn affidavit application system was the precise opposite of least restrictive. It was deliberately designed to maximize burden and minimize compliance. The court saw through it completely. Here is my question for you. Drop it in the comments right now. Which politician in your state do you think is most responsible for these kinds of discriminatory carry restrictions? Name them. I want to see who this community holds accountable. Here is the part of this story that mainstream media is completely ignoring because the implications of Miller versus California go far beyond the state's 39 million residents. The equal protection framework that won in this case applies with identical force to carry restrictions in every other restrictive state in America. New York does not recognize out-of-state permits. Under the MillerVCalifornia framework, equal protection violation, Hawaii treats non-residents differently for the exact same constitutional right. Strict scrutiny failure. New Jersey effectively bans all non-resident carry. Unconstitutional under this legal reasoning. Connecticut, Maryland, Massachusetts, Illinois. All of them operate versions of the same discriminatory system that just got permanently enjoined in California. Within 72 hours of the ruling, 3 new federal lawsuits were filed, one in New York, one in Hawaii, one in New Jersey. All 3 cite Miller versus California directly. The legal blueprint is already deployed and moving through the courts right now. There is also an economic angle that almost nobody talks about. Analysts estimate that reciprocity restrictions cost states like New York nearly $847 million annually in lost tourism revenue. Gun owners who would otherwise travel to those states, attend shows, visit ranges, spend money at hotels and restaurants, simply choose not to go because carrying legally is impossible. When states keep losing in federal court and losing revenue and facing political pressure, something eventually has to give. Tell me in the comments, which state do you think it's challenged next? Type New York, Hawaii, New Jersey, or Massachusetts. I want to see where this community thinks the next legal battle lands. One of the most important aspects of this ruling that legal scholars are discussing is how difficult it is to reverse, even for gun-skeptic judges. Most Second Amendment victories get challenged by anti-gun courts on the grounds that the Second Amendment right is limited in scope or that public safety concerns override it. Those arguments, while legally wrong, have enough traction in certain circuits to create problems during the appeals process. The equal protection argument is different. Every single judge, conservative or liberal, is bound by the Equal Protection Clause. Treating people differently based on where they live when they are exercising a fundamental constitutional right is discrimination. It requires compelling justification. California had none. That argument does not dissolve when it reaches a gun-skeptic judge. It is grounded in constitutional principles that apply across the ideological spectrum. And here is the critical practical difference with a permanent injunction versus a panel ruling. California officials, including Attorney General Rob Bonta, are now under a direct federal court order. Violating that order is not just legally problematic, it is contempt of federal court. The legal force behind this ruling is significantly stronger than a typical appellate decision. California has to either appeal and seek a stay or comply, and compliance means gun owners win immediately while the appeal plays out. Let me give you the realistic timeline, because understanding what comes next is just as important as understanding what just happened. California's Attorney General will almost certainly appeal to the Ninth Circuit. That appeal is coming. The question is whether they successfully obtain a temporary stay while the appeal proceeds. A stay would pause the injunction, meaning California could potentially resume enforcement while the legal process continues. But here is the key strategic reality. Courts grant stays based on the likelihood that the appealing party will ultimately succeed. Given the strength of the equal protection argument, and given that California already failed to justify its discrimination under strict scrutiny, obtaining a stay is not automatic. It is not even certain. Judge Ramos found California's arguments unpersuasive at every level. An appellate court granting a stay would essentially be saying those arguments might succeed on appeal. That is a hard case to make when the trial court ruling was this clear and this comprehensive. If the Ninth Circuit denies the stay, the injunction holds during the entire appeals process. California cannot enforce the discriminatory law. Out-of-state permit holders can carry legally in California while the legal battle continues. That is an enormous practical win, regardless of what ultimately happens at the appellate level. level. And if this reaches the Supreme Court, the current 6-3 conservative majority has consistently ruled in favor of Second Amendment protections. Thomas, Alito, Gorsuch, Kavanaugh, Barrett. These are the justices who established the Bruin Standard in 2022. The equal protection argument on top of the Second Amendment foundation gives this case two independent constitutional legs to stand on. That is a very strong position before the current court. Here is a question I want you to answer honestly in the comments. What is your favorite Second Amendment ruling of the last decade? Heller, McDonald, Bruin, or something more recent? Drop it below. I am genuinely curious what this community considers the most important legal victory we have had. Let me get practical, because Gun Guide Pro exists to give you information you can actually use. If you are a gun owner who travels to California, monitor this case extremely closely over the next 60 to 90 days. The injunction is in effect right now, but if California successfully obtains a stay pending appeal, enforcement could resume. Do not make permanent decisions about carrying in California based on the current ruling without checking for updates. This is exactly why subscribing to Gun Guide Pro and turning on notifications matters. When the stay decision comes down, you will know within minutes. If you live in New York, Hawaii, New Jersey, Massachusetts, or any other state that discriminates against out-of-state permit holders, the lawsuits filed in your circuit are the cases to watch right now. The Firearms Policy Coalition, the Second Amendment Foundation, and Gun Owners of America are all actively litigating these challenges. Support these organizations financially if you can. Their legal work directly funds the cases that protect your rights. If you are a gun owner in a constitutional carry state, do not tune out. A Supreme Court ruling establishing nationwide carry reciprocity raises constitutional protection for every gun owner in every state. What happens in California's courts eventually affects your rights too, and regardless of what state you are in, know your state's current laws precisely. The legal landscape is shifting fast. What was illegal 6 months ago may be protected today. What is currently protected may face new challenges tomorrow. Staying informed is not optional. It is essential. Step back for a moment and look at what is actually happening in historical terms, because I think it is easy to miss the scale of this when you are watching it unfold case by case. For over a century, states have operated under the assumption that the Second Amendment is a second-class right, that it can be regulated far more aggressively than speech, religion, or assembly, that bureaucratic barriers, discriminatory requirements, and targeted restrictions are acceptable as long as they are framed around public safety. Heller cracked that assumption in 2008. McDonald extended it to every state 2010. Bruin demolished the interest balancing test in 2022 and replaced it with the historical tradition standard. And now Miller versus California adds the equal protection dimension, establishing that states cannot treat the Second Amendment as a right that applies differently based on where you were born or where you currently live. Each of these rulings builds on the last. Each one closes a loophole that anti-gun states were exploiting. Each one raises the constitutional floor that all gun regulations must clear, and each one makes the next challenge easier to win because the legal precedent is accumulating in our favor. The states that are still fighting, California, New York, New Jersey, Illinois, they are not fighting from a position of legal strength. They are fighting from a position of institutional inertia. Decades of restrictive legislation that courts are now systematically examining and invalidating. The question is not whether this legal trajectory continues. The question is how fast it moves. And that speed, that pace of legal progress is directly influenced by how organized, informed, and engaged the gun-owning community is. Channels like Gun Guide Pro exist for exactly this reason. Not to generate outrage, not to sell you something, to make sure you understand what is happening legally, clearly, accurately, and in time to act on it. Here is the absolute bottom line. For over 20 years, California told law-abiding gun owners from other states that their constitutional rights ended at the state line. They built a discriminatory system that turned permit holders into felons, and when a court told them to fix it, they tried to replace it with a bureaucratic maze that achieved the same result through different paperwork. On August 19, 2026, federal Judge Patricia Ramos said enough. The permanent injunction is in place. The law is unconstitutional. California is under a federal court order not to enforce it, and the equal protection framework that won this case is already being deployed against similar laws in New York, Hawaii, and New Jersey. The Second Amendment does not have a residency requirement. Courts are finally enforcing that truth, and Gun Guide Pro is going to be here covering every single development as it happens. Here is what you do right now. First, subscribe to Gun Guide Pro and hit that notification bell immediately. We are a new channel, and we are building this community one informed gun owner at a time. Your subscription is not just a number, it is what keeps this content coming. Every subscriber gives us the motivation to keep going and bring you even better coverage. Second, smash that like button and share this video with every gun owner you know who travels or has ever been told their permit means nothing at a state line. Third, answer all 3 of my questions in the comments. Which state stopped you from carrying? Which politician do you hold responsible for these restrictions? And which state do you think gets challenged next? New York, Hawaii, New Jersey, or Massachusetts? I personally read and respond to every single comment on this channel. We are just getting started at Gun Guide Pro. The cases coming over the next 12 months are going to be historic. Be here for them. Stay informed, stay armed, stay free. I'm Michael from Gun Guide Pro. See you in the next one when California files their appeal.